This honorable court is now in session. Please be seated.
And I think everyone was here for those preliminary announcements. Please ask for your rebuttal time when you come up and let me know how you're splitting the arguments. Any preliminary matters?
No, Your Honor.
Okay, you may call the case.
Jessie Dotson versus State of Tennessee.
Good morning. Your Honors, may it please the court. I am Andrew Harris, and along with Kelly Gleason, we represent Appellate Jessie Dotson. I'd like to reserve 5 minutes for rebuttal. We're here today because Jessie Dotson, a capital post-conviction petitioner, was denied funding from mental health and false confession experts after the post-conviction court found that expert assistance was necessary to effectuate his constitutional rights. The AOC Director and the Chief Justice vacated the post-conviction court's orders granting expert assistance, and in doing so, the AOC Director and Chief Justice, two administrative decision makers, usurped the post-conviction court's judicial determinations, despite not having the authority to exercise judicial power. This was done without authorization by statute or the Tennessee Constitution to exercise judicial authority. The application of Rule 13 in Mr. Dotson's case violated Articles 2 and 6 of the Tennessee Constitution. Our legislature gave the trial court the authority to provide expert funds to capital post-conviction petitioners to insulate our state courts from federal court oversight in the interest of finality, and we ask that this court to act to protect the integrity and the finality of the state court post-conviction process by finding that when the AOC Director and Chief Justice engaged in a substantive review of the post-conviction court's funding orders and vacated them, the AOC Director and the Chief Justice unconstitutionally exercised judicial power.
Well, doesn't the Chief Justice have judicial power? And couldn't the Chief Justice rule on that?
According to Article 6, Section 1, the Chief Justice does, but in this capacity, overseeing the AOC, the Chief Justice is acting as an administrator. Right, according to Article 6, Section 1, the Constitution creates this court and gives the General Assembly power to create inferior courts.
Well, Mr. Harris, the General Assembly appropriates the funds for indigent representation in the state, whether it's for defense counsel, experts, or whatever. What if the Administrative Office of the Court's Director and the Chief Justice looking at the funding just says, we don't have the money for this? Isn't that just purely administrative?
In that instance, that would be an administrative decision, but that was not the case here.
And would you have any problem with that? If that were the basis, would any of your arguments still hold?
If that was the basis, if the AOC Director and Chief Justice refused funding because they had no more money, that would be a valid administrative reason, Justice Campbell. However,
but we don't know what the reason was here because that's not in the record, isn't that right?
We don't know the reason, and that's one of the problems. It's this black box process. But what we do know is that obviously we filed motions for 4 experts, which were granted by the court, and we tried to make a record. We tried to supplement the record 4 times. We went to hearing on the protest. We told the post-conviction court on the record numerous times we were denied experts.
But the fact remains that's not in the record, right? We don't have, this is an as-applied challenge to this particular decision, and because we don't have information in the record about what the basis of the decision was, I mean, we can't assume that it was a substantive decision versus an administrative decision. We don't know. It's entirely possible that it was for the reasons that Chief Justice Page suggested, that, you know, there just wasn't enough funding.
I respectfully disagree, Your Honor, because we do know that we attempted to supplement the record, and as an officer of the court, I can tell you that we were told by the AOC director that we were not approved for Dr. Marikangas and Professor Leo because
Is this in the record, what you're telling me just now?
it is not.
Okay, let's move on then. I'm sorry, I didn't mean to lead you down that road, but let's stick to what's in the record.
But obviously, if we got the funding, Your Honor, we wouldn't be here. There's no question that, I mean, the record is complete enough, I think, for the court to understand that we were not afforded expert assistance in this case.
Can you articulate for me, I guess, what you're arguing is the interest, to have a due process violation, there has to be some protected interest, liberty interest, property interest. Can you be, I guess, precise about what the interest is in this case?
In a capital case, Your Honor, clearly there's a life and liberty interest.
But we're talking here about the funding, the denial of funding. If we look sort of narrowly at the constitutional argument you're making as it pertains to the lack of an appellate remedy for the denial of funding. So doesn't the interest have to relate in some way to the denial of funding rather than the kind of the interest? The defendant has an obvious interest in, life and liberty in a capital case, but the narrow issue we're looking at is the lack of an appellate remedy for the denial of funding. Isn't that right?
That's not the only issue before the court, Your Honor. It's also the underlying actions of the Chief Justice and the Administrative Director denying overruling the lower court.
Did you preserve those issues?
Yes, according to the Hodge case, in the application, we fully briefed both issues, the appellate remedy and the underlying actions of.
Did the issue presented, the actual listing of the issue presented, did that include those issues?
It did not, but Hodge v. Craig, this court says that does not have to be the case as long as the issue is fairly presented in the application and also in the briefing, which it was. And I direct this court to State v. Linville, which is a case the state referenced in their brief. And in Linville, one of the questions raised in the brief was not even raised, I believe not raised until oral argument, was not raised in the application. I don't think it was raised in the brief, but certainly not in the application. The court still considered it. So the court obviously has the authority to consider issues outside the question, and I think according to this court's jurisprudence, the underlying actions of the Chief Justice and Administrative Director are clearly before the court.
What do you think is you make a number of arguments as to why this is unconstitutional. I'm not asking you necessarily to kind of rank the arguments, but I am curious as to your thoughts about what your strongest, what in your view is your strongest argument?
I think the state constitutional issues, in particular the Article 6 and Article 2, where you have administrative actors exercising judicial authority and overturning a court.
And so that goes not to the lack of an appellate remedy, but I guess clarify for me whether that is about the lack of an appellate remedy or the denial of funding more generally.
Well, it's certainly about the denial of funding, but I think the two issues, as it presented in this appeal, go hand in hand. But it certainly speaks to denial of funding, where you have the post-conviction court on 4 occasions finding there was a particular need in extraordinary circumstances for these experts, and then they're overruled by the Chief Justice and the AOC Director.
But under your argument, would every request for funding then have to be granted? Could the Chief Justice deny any request for funding?
Of course the Chief Justice can. There are certain things the Chief Justice can do to the administrator. So for example, in this case, we were denied Dr. Agarkar because he was approved by the lower court for $350 an hour, and the rule specifically says $250. So in that case, that was an administrative decision which it was proper.
So was that a proper decision? Do you?
Yes, because the court
it exceeded the rule, the amount.
Yes, because it
hourly
exceeded
amount.
the amount.
Okay.
In the case of Dr. Agarkar.
Also, in many of these cases, you have the application or the motion don't meet the requirements of the rule. And there's nothing wrong with the Chief Justice denying them in that case, correct?
I would think so, but in this case, we clearly met the requirements of the rule. But I think, for example, if another example, I think, which would be administrative decisions, that the lower court approved an expert that was not an expertise that the rule contemplate or recognized by science. But in this case, we're talking about a psychiatrist and and a neurologist and a false confession expert. These are experts that are routinely used in these cases and are vital in post-conviction and capital cases, particularly mental health experts.
To prevail in this case, do you have to prove deficiency and prejudice just like any other post-conviction case?
Well, this is not an ineffective assistance of counsel claim, so I don't think it has that component.
Okay.
Turning back to what Justice Campbell asked, I think our lead argument is that finding that what happened here, the AOC review process violates Article 6 and Article 2. And I don't think that requires a finding of deficient performance and prejudice.
But in order to find that hinges on your assertion that this was exercising judicial authority as opposed to an administrative decision, because you characterize it as overturning the findings of the trial court that this was necessary. So I'm trying to figure out, you indicated that if the Chief Justice just looked at what was left in the Indigent Representation Fund and said there's not enough money for this, that's clearly administrative.
Yes, Your Honor.
So how do we know on this record that it wasn't just administrative? I mean, because there are many different ways to marshal the finite amount of funds in the Indigent Representation Fund. You could just greenlight all the requests until you run out of money in September, and then everything after that is just denied. Or you can make judgments, if you're the AOC director and the Chief Justice, you can make judgments along the way that don't go to the trial judge's finding of necessity, but still doing some looking at all this array of requests with an eye toward what's left in the fund. So there are different ways to make an administrative decision. Your argument hinges on us finding that they were exercising judicial authority. So what is there in this record that tells us that they were actually overturning the trial judge's findings as opposed to an administrative decision?
The record is not clear for the specific reasons why the AOC Director and Chief Justice acted, but it's a reasonable assumption that they overturned the decisions of particularized need and extraordinary circumstances. And we've attempted to supplement the record with those reasons on 4 different occasions, which would have at least clarified some of that for the court.
Well, the defendant's getting full court review now of that request and that denial. Does that take away your argument that there's a violation of the Tennessee Constitution? I mean, you're getting 4 justices to hear your claim.
And what we're asking this court to do is to find that there was a violation in this case, that administrative actors overturned judicial decisions, and as a result, the remedy for this case would be the remand to overturn the post-conviction decision denying relief, remand and allow us to reinstate the post-conviction court's orders and allow us to have a hearing and putting on those experts.
Well, that goes back to my question earlier about post-conviction. So you then still would have to prove deficiency and prejudice in your post-conviction hearing, right? And if you can't show us that these experts that you were denied would help you in doing that, then where does that leave us?
Well, I think in the case, it's clear that when we have the finding of particularized need, this is a case where there is, as laid out in the expert motions, which are a part of the record, that you have a death penalty case, an aggravated case, where the defendant appellant has this significant indicia of mental illness. And the court found as a result of that there was particularized need for the experts, and also found when we reached the $25,000 that there was extraordinary circumstances to allow for expert assistance. And we know the importance of mental health experts in these cases. We need to look no further than this case, this court's opinion in Davidson, where this court granted sentencing relief for the failure, based largely in part on trial counsel's failure to develop and present mental health evidence and mental health experts.
You also argue that you were denied a full and fair hearing because of the denial of these experts. Does does the prejudice aspect come into play in that argument? I mean, we've asked you about whether you have to show prejudice, but it seems to me in that aspect of your argument, the full and fair hearing prong, don't you have to show prejudice?
I think
Sustain
prejudice
that
is
argument?
I think prejudice is putting the cart before the horse. I think the issue here is that Mr. Dotson was never given a chance to develop and present these claims. So I don't think there's a requirement of showing a prejudice.
Let me ask you this. We have, under our rules for the Supreme Court, if we have a case coming up for the five of us, and I'm asked to recuse and I deny that motion, then the movement can appeal to the other four justices. Would a procedure like that satisfy your concerns in this arena?
That if, once we got the denial from the AOC, if we could have appealed to this court, I think an interlocutory appellate remedy is one of the ways to remedy this problem. And while we don't address it in our briefing, the amici certainly do, and they do a survey of various states, and that seems to be one of the ways, I think probably the best, one of the better ways to alleviate this issue. Yes, Your Honor.
Yeah.
But you're also arguing that the denial itself, I mean, even, or at least as I understand your argument, you know, there's the lack of an appellate remedy argument, but then there are these distinct arguments that really go to the denial of funding. You know, even if there had been, let's assume that this procedure that Chief Justice Page had just outlined had actually occurred and the other justices agreed that the funding request should be denied. As I understand your argument, you are still saying that the denial, that not having access to these funds to raise these arguments in your post-conviction proceeding denied your client a full and fair hearing in violation of the Due Process Clause. Is that correct?
I think that's one of a number of arguments that we're raising, but I think the critical argument here is that you had two administrative actors overturning a judicial determination. So in the potential solution that Chief Justice Page mentions, in that case, an interlocutory appeal, if it was set up that way, if the rule was revised that way, you would have this court making a judicial determination. So, for example, if we denied Dr. Marikangas by the AOC director and the Chief Justice, and we appeal to this court, and you find no extraordinary circumstances or no particularized need, I think that would be fine, and you'd be making a judicial determination, assuming there were three justices who concurred.
And you wouldn't still have an argument then that you're constitutionally entitled to these funds, even if we have this, you know, elaborate procedure in place to review all of these determinations along the way.
I think in that case that we're talking about, if there was an interlocutory appeal, I think that the court would be making a judicial determination that the experts weren't necessary. I find it hard to believe that in this case that a deaf or inmate would be denied mental health expert assistance. I've been litigating these cases for over 20 years, and I've never gone to hearing in a case where there was significant indicia of mental health impairments and not have a mental health expert.
But we have more cases where that evidence is necessary than we have funds. So what do we do with that? I mean, you're saying that it's a constitutional violation every time we are trying to marshal the limited funds that we get. We do not have the money to grant all of these. So under your theory, every time a trial judge finds that it's necessary and there's not enough funds for all the times that a trial judge finds it's necessary, there's a constitutional violation.
Correct, and there would be a remedy in that case. If that were to happen, if we were to be told specifically that we were not permitted a mental health expert in this case because there was an absence of funds, we then could have filed a motion or would have filed a motion in the trial court to vacate the death sentence as a result, which is what we actually did try to do when we were denied, which we did do when we were denied Dr. Agarkar at $350 an hour. So it would still be a remedy for Mr. Dotson if there were no funds.
And that is to vacate the sentence?
That's what I would file in that instance, yes, Your Honor.
So the answer to my question is yes. If the trial court finds that it's necessary and the Supreme Court says we don't have enough money for it, then everybody that there's not enough money for gets their sentence vacated?
They would have an option to litigate this. We're talking about a very small universe of cases. I can't speak to every case where there's an expert request with the AOC, but I do know, in my experience in capital cases, this was unheard of, that we were denied expert assistance and essentially held to $25,000 in Ms. Dotson's case, when there was repeated findings of particularized need and extraordinary circumstances to exceed that cap. Just looking at the case law of Davidson, the U.S. Supreme Court in Wiggins, Rumpiller, Sears, Porter, we know the vital importance of developing mental health evidence and presenting mental health experts. This was not an unusual or extraordinary request in this case. To have a death row.
That's kind of the point. It's not just in capital cases. In many cases where somebody's liberty is at issue, there are underlying mental health issues and a desire and sometimes a finding by a trial court that it's needed. But there are not enough funds for that. And you're saying that every time that happens, it's a violation of the Constitution.
I can't speak to, Your Honor, how many funds are available, but I believe in this case, if all of our requests were granted, it would have been below $50,000, which for a capital post-conviction case based on other cases our office has litigated is not an unusual amount.
But you were asking to exceed, and so I think it is important to clarify that, there had already been $25,000 authorized and granted in this case. I mean, these requests took the amount above the cap and above the hourly cap in the case of the first request. And, to Justice Kirby's point, there are other cases where the defendants or the post-conviction petitioners are just requesting funds to get up to that $25,000 cap. So I do think it's significant that, we're talking about kind of amounts in excess in a universe where we have limited funds to allocate among not to just one capital defendant, but among a lot of capital defendants who are requesting these funds.
Or non-capital defendants.
Well, non-capital post-conviction petitioners are not entitled under Rule 13 to expert assistance. But assuming that's the case, Your Honor, and I don't know what the funding of the AOC is. If that's the case, it goes back to the issue. And last year, the U.S. Supreme Court handed down a decision in Shin v. Ramirez talking about the paramount importance of the state post-conviction process. If that's the case, if your petitioner is being denied expert assistance, if there's not, for whatever reason, if they have a good reason, if there's not funding, we'll be faced with a situation where there won't be, under the habeas statute, there won't be deference under 2254D. Under 2454B, under that B1 specifically, there'd be an absence of there'd be a problem with the state corrective process, and the state would not be allowing capital post-conviction petitioners to develop the record in state court. As a result, they would get de novo review, and I think that could result in the federal court reaching down and encroaching on the state post-conviction process, essentially rendering the state post-conviction process, in death penalty cases at least, a nullity.
But you're trying to extend. I mean, you cite cases in your brief that are pertain to the direct appeal stage. Whether it has been recognized that there's a constitutional entitlement, for example, to counsel and to funding in certain circumstances. I mean, aren't you trying to extend those to the post-conviction context? I mean, it's one thing if, as a matter of legislative grace, these procedures have been made available to capital post-conviction petitioners, but it's a pretty big step to take from that, that there is a constitutional entitlement to this.
I think, Your Honor, there is a statutory right to post-conviction in Tennessee, and when the state affords a statutory right to the post-conviction process, due process rights do attach, and this court has held.
Where is that statutory entitlement? So to go back, I guess, to my first question that I asked, in this argument, what can you point to that creates a statutory entitlement to this funding?
Well, it's the expert funding statute that allows.
Doesn't that ultimately give the court discretion? I mean, in other cases where there has been some sort of property interest created from a statute, it's because there were kind of meaningful standards that cabined the discretion of the official decision maker.
And I think this court has found, and we cite it repeatedly in our brief, in Whitehead v. State, Howell v. State, that this court has talked about the importance of due process protections in post-conviction specifically, and then obviously heightened due process, such as in cases like Van Tran, in death penalty cases.
But we have to be precise about the analysis. I mean, we can't just sort of wave our hands and say there's a due process right. I mean, what is the specific liberty or property interest that we're talking about here? And how have the procedures that currently, how do the procedures that currently exist surrounding that interest fail to provide due process?
This is a death penalty case, Your Honor, so obviously Mr. Dotson has an interest. His life is at stake in this proceeding. And without allowing to present expert assistance, he could very well be executed as a result without having a chance to present evidence that the court found was, experts that the court found was necessary to support his claims. Thank you, Your Honor.
May it please the court, good morning, Your Honors. Courtney Orr on behalf of the state of Tennessee. The question before this court is whether lack of an appellate review from the AOC Director and Chief Justice's Rule 13 review violates various federal and state constitutional rights. To the extent that Mr. Dotson now challenges the substance of the administrative Rule 13 review, those challenges are beyond the scope of this appeal. And alternatively, the record is not adequate for this court to review those decisions in this case. I'll note it appears that the defendant is now conceding that the AOC Director and Chief Justice's review of Dr. Agakar's funding request was an administrative review that was proper under the Constitution. That is the only review that we have a record for in this case. And I also would like to note, to the extent that the defendant is arguing that Article 6 of the Tennessee Constitution would grant or is implicated by this Rule 13 review, that is not anywhere within the statement of the issues presented to this court. It was addressed in the substance of the Rule 11 application. He has briefed it in his brief here. But the statement of the issue presented to this court and the statement of the issue that was granted in this court's Rule 11 order does not address the AOC Director acting as a judicial authority or whether Article 6 of the Tennessee Constitution is implicated in this case.
So is our scope of review dictated by what is included in our grant order?
I believe so, Your Honor. Under Hodge v. Craig, and I believe the defense and I probably have a disagreement on what Hodge v. Craig says.
There might be a little disagreement with the state in terms of the argument in our last case, where the state has raised an issue that was not in the grant order in Thomas and Turner, but I didn't make that argument.
Yeah, I hesitate to comment on the last case without their counsel here. I will say that this is a little bit distinguishable because this is an entirely new constitutional theory that he is presenting that is not in this Rule 11 grant order. It is not a common law rule that is subsumed within a sufficiency of the evidence review. So there is a bit of a distinction between that. But here, he is arguing an Article 6 violation of the Tennessee Constitution, where Article 6 was never included in the statement of the issue presented in the Rule 11 application or in the Rule 11 order granted by this court.
If this argument of denied funding had been raised in the initial guilt, innocence phase of the trial, would that be on different footing than raising it in a PC claim, in this PC claim?
I want to make sure I understand Your Honor's question about denial of funding. Are we discussing the Dr. Gatkar that exceeds the hourly rates or the $25,000 cap?
I suppose exceeding the cap.
Okay.
Just their argument, they were denied a full and fair hearing, they were denied due process because they didn't get this funding. Is that argument different in the initial guilt innocence phase than it is in the PC stage, which is by statute?
Yes, for two reasons, Your Honor. First, the $25,000 cap only applies to capital post-conviction defendants. It does not apply in the direct appeal or at the trial level. And I think that is a recognition of the ruling in Akey, which says that criminal defendants are constitutionally entitled to expert assistance at their trial. But Akey, as Justice Campbell pointed out, has not been extended to post-conviction in this state. And indeed, the U.S. Supreme Court, in a case out of Alaska, District of Attorney's Office versus Osborne, has ruled that a defendant is not constitutionally entitled to expert assistance. In that case, it was DNA testing in post-conviction litigation. Akey simply does not apply in the post-conviction context. So yes, this is on different footing than it would be in a direct appeal context.
In order to prevail, he has to file a challenge. Does the petitioner here have to show that had these funds been granted, the outcome of the PC hearing might have been really different?
I would believe so, Your Honor.
This time has to be the normal post-conviction rules, legal prejudice apply.
I think so, and to be
Wouldn't
clear,
that go to, I mean, you're saying that we should not get to the substance of the decision.
yes.
Isn't that tied to the substance of the decision?
It is tied to the substance of the decision.
I see you hesitating.
Yes,
there.
it is tied, and I want to answer this court's questions fully, but also cognizant of the fact that the Rule 11 grant is the scope of this appeal. But yes, Your Honor, I believe that you would have to show prejudice in that I think that would be different from the Strickland prejudice to show that there would have been a different outcome at trial, but you would have to show that you would be able to bring in some sort of evidence that would have been beneficial to you. But I don't even think this court needs to get to that question in this case because, again, as I've noted, this is outside, the substance of this review is outside the scope of this appeal. But even if this court were to get to it, the record does not support or would not allow this court to review whether the AOC and Chief Justice's review was constitutionally improper, simply because we do not know what happened. All we know in the record is an announcement from counsel that those funding decisions were denied.
Are you trying to say we should not have granted application on this case?
That's not what I'm arguing here today, Your Honor. I'm just trying to address the arguments that have been raised before this court about the substance of the review as fully as I can based on the record before us.
Well, let me ask you this. I mean, is it your position or is it the state's position that, especially as it pertains to the sort of separation of powers argument that the petitioner is making here, that the AOC director and the Chief Justice are somehow kind of limited to administrative reasons for denying? I mean, could the Chief Justice deny this funding request based on a disagreement with the trial court's determination, which seems to me to be a very legal determination, that these services are, that this case involves exceptional circumstances that necessitate this expert assistance?
There is nothing in the rule that would prevent that. Nothing in this text of the rule. I will note, as Your Honors have noted, this is an as-applied challenge. This is not a facial challenge to the rule.
So let's assume, I know we don't have a record in this case, and I do think that that makes review a little more challenging, but let's assume that we had a record in this case that says, where it's clear that the Chief Justice was denying this funding based on a substantive disagreement with the trial court's exceptional circumstances determination. How does that change the state's position?
I think It depends on whether you're discussing exceeding an hourly cap versus exceeding the $25,000 cap. If you're talking about the Chief Justice reviews and says, this has been granted at $350 an hour, the rule only allows $250 an hour, that is a purely administrative review, even if it is based on a disagreement.
If the Chief Justice disagrees that there's a particularized need here, and you don't need this expert, that's substantive, that's not administrative, right?
Right, let's say we're not even in the kind of exceeding caps or exceeding hourly, maximum hourly rate world. What if this is just a
straight
straight
deny.
up, within that, it's under that $25,000 cap, the rates are below the caps on hourly rates, and it's a disagreement, as Chief Justice Page said, with the particularized need determination.
I would agree that that begins to look more like a substantive appeal. I hesitate to say whether that would be a constitutional violation, again, because of what is the issue presented before this court. But it does, I think, would raise significant concerns.
Separation of powers concerns, or I guess improper exercise of judicial power.
Yes, I believe that
concerns.
would be the improper use of, or exercise of judicial power, which, again, that's not the case or not the record that we have before this court. Well, the record we have is a administrative review of a funding request that exceeds the hourly caps. Nothing within the rule allows the post-conviction court to exceed enumerated hourly caps. And this court has held in Petitioner of Gant that when the rule sets out a specific hourly rate, that is per se reasonable.
So are you saying then that in those circumstances where it's exceeding the cap, it's exceeding the $25,000 maximum, that the actions of the AOC director or Chief Justice is necessarily administrative?
Yes, and I believe that gets to Justice Kirby's questions in the prior argument, or my friend's argument, that this is looking at, here is the order, here is our budget, what do we have? That falls within that gamut of the order grants hourly rates at $250 an hour. There is no authority that allows a court to exceed that. So instead of conducting a substantive review regarding whether they disagree or agree with this decision, or whether there was a particularized need, instead, the record we have shows that the AOC director and the Chief Justice granted approval of the court's order to the maximum allowed by the rule. And that is an administrative decision.
Does the record reflect that there are expert services approved up to $25,000 in this case? I mean, do we know whether these would have exceeded the cap, according to the record?
The defendant's motions are in the record. Dr. Agakar's does not exceed the $25,000 cap. It is the hourly rates. The Dr. Leo, Dr. Walker, and Dr. Mary Kangas, the defendant concedes in his motions that they all exceed the $25,000 cap. I will note that for Dr. Walker, the defendant states in his motion that the $25,000 cap should not apply because Dr. Walker was going to be called as a fact witness. And Rule 13 does not permit, or nor does the statute permit funding for a fact witness. But I do want to turn quickly to the issue that is before this court, which is the lack of the appellate remedy. The defendant is proceeding under the theory that the Post-Conviction Procedure Act grants him a right of appeal from this AOC director's decision. The Post-Conviction Procedure Act does no such thing. The right of appeal in the Post-Conviction Procedure Act applies to a final judgment by the actions of the post-conviction court. That does not encompass the AOC director's review or the Chief Justice's review for a prior approval of an expert funding decision. Mr. Dotson now is not seeking review of the post-conviction court's order. Instead, he's seeking review of the AOC director and Chief Justice's decision, which fall outside of the right of appeal granted under the Post-Conviction Procedure Act. Nothing in rule or statute grants a right of appeal from the AOC director and the Chief Justice's review, and that doesn't.
Isn't that the point? Isn't that the point he's making?
Yes, it is, but that does not implicate.
We have nowhere to go on this.
Correct.
And ergo, there is a violation of my constitutional right to due process.
And our response is, correct, there is no right of appeal, but that does not violate your rights, constitutional rights. First, the right to due process, which I think is probably the overarching concern. Evans versus Lucy states that when there is no created right of appeal, when the legislature has not established a right of appeal, or the rules have not established a right of appeal, there is no requirement that the state provide a right of appeal. That is the case here. The General Assembly has not granted the defendant the right to appeal from the AOC and the Chief Justice's Administrative Rule 13 review. And there's no constitutional requirement that that appeal be created.
Wouldn't that be for the court to decide? Because it's our rule. Rule 13 is created by this court, correct?
Rule 13 is created by this court, yes. And if this court were to decide that it wanted to grant a right of appeal, it certainly is within its prerogative to do so. Our argument is that there is no constitutional requirement that you create a right of appeal.
You refer to the Federal Criminal Justice Act and draw a comparison between that and cases, considering whether similar procedures under that act violate due process and our procedures. One difference is that courts have held that for the federal act, the federal CJA, a person can seek a writ of mandamus from the U.S. Supreme Court. So the chief judge of the relevant circuit can, and I think that act just deals with kind of the excess situation where you're kind of above the cap. But in that situation, there is at least somewhere else to go. Granted, that would be a hard row to hoe to actually get a writ of mandamus in those circumstances. But is that a material distinction that at least there is some avenue for getting review of, or at least, directing the chief judge to take a different action? And there's nothing here? Or is there something that we're missing? I mean, is there some other path to relief here, even though our rule says the decision is final?
The rule does say that the decision of the Chief Justice is final. I don't believe that would necessarily prevent a defendant from, potentially seeking a petition for writ of certiorari. As far as the record reflects, Mr. Dotson did not attempt to do that here. But to answer your initial question, no, I do not believe it is a material distinction because it is still an administrative review that, based on the record that we have, is simply just looking at the budget and what this grant is. I do not believe, because the distinction with the Criminal Justice Act, and I agree it is not on all fours with Rule 13, is that any excess request has to go to the chief judge, and it doesn't initially, or does not does not explain whether the chief judge could then look into, well, have you established a particularized need or anything like that. So, no, Your Honor, I do not believe it would be a material distinction. But here, there is no violation of the right to due process simply because there is no due process right to creation of an appellate remedy. Similarly, there is no equal protection violation by a lack of appellate remedy in this case. The defendant, Mr. Dotson, highlights extensively the other cases that have come up before the Court of Criminal Appeals in which the post-conviction court initially denies the request for prior authorization of expert funding. Those are orders of the post-conviction court, which are reviewed on appeal from the Post-Conviction Procedure Act. But that is not a distinction from Mr. Dotson's case. Instead, every single capital post-conviction defendant is in the same position. Had Mr. Dotson requested these funds and had they been denied by the post-conviction court, he still would have been able to seek review of that post-conviction court order in his appeal from the post-conviction proceedings. Instead, he got that order and it went to the AOC, and that's where the denial came from.
Isn't that the dilemma here? You have an appeal if you're denied in the trial court, but not if you're granted in the trial court and then denied by the Chief Justice and AOC Director.
Respectfully, Your Honor, I do not believe that that is a distinction or a dilemma here because, hypothetically speaking, I believe Mr. Adley was one of the cases where it was reviewed by the Court of Criminal Appeals. Had Mr. Adley gone to the Court of Criminal Appeals and said the post-conviction court abused its discretion when it denied my funding request, the Court of Criminal Appeals said, we agree. We are remanding this case back for the post-conviction court to review and look at this funding prior approval again. That does not equate to a grant of funding for expert services. Instead, Mr. Adley would have gone back to the post-conviction court. The post-conviction court would have then granted or denied The
And
prior
then the
authorization
AOC
for-
director and chief justice would have. Is that it?
Potentially, we don't know. I don't know what the state of the AOC's budget would have been those many years ago, but had it been granted, had prior authorization been granted after remand, then Mr. Adley would have been in the exact same position as Mr. Dotson, in which the case would have gone to the AOC director and the chief justice, and there would have been no right of appeal. There is simply no distinction between how the law treats capital post-conviction defendants. The only distinction here is how the facts played out in each of these cases. Similarly, there is no violation of the Tennessee Open Courts provision, the Tennessee Constitution. The Open Courts provision simply states that when the legislature creates a right to seek a remedy, that the courts have to be open for that remedy. Here, the only remedy that the legislature has, or the right the legislature has created, is the right to petition the court for prior authorization of funds. It does not create a right to those funds. It does not require that the court's order be a grant of those funds. It is simply a prior authorization of those funds, which is then subject by statute to rules set forth by this court, which is Rule 13. The courts are open to that legislative right of action, and Mr. Dotson availed himself of the courts in this case. And as we noted earlier, due process does not require creation of a right of appeal when the legislature has not done that, and neither does the Open Courts provision. Next, turning to the right of full and fair hearing, I'll note Mr. Dotson does not make an argument about how lack of an appeal implicates his right to a full and fair hearing. His argument seems to be based mostly on the assertion that he has a right to expert assistance in the post-conviction court. He does not under Osborne. But also, the lack of an appeal here would not have violated the right to a full and fair hearing, simply because, as I noted, he has no constitutional right to expert assistance in a post-conviction proceeding. To the extent that he is relying on AICI has not been extended to post-conviction procedures, and the U.S. Supreme Court in Osborne suggests that it should not be extended to post-conviction procedures.
Well, post-conviction procedures in the state are entirely statutory, correct?
Yes, Your Honor.
What if the legislature just abolished it? Where would that leave us? Somebody looks at everything and say, you're spending way too much money on experts in these cases, we're just going to abolish PC in capital cases. Where would that leave us?
I want to make sure I understand your question.
I
Abolish
guess I'm asking-
post-conviction entirely or abolish funding?
I've always been concerned that the legislature would just pull the purse strings if we're spending too much money in these cases.
Mm-hmm.
And I guess I'm asking you, do you think they constitutionally can do that?
Yes.
Okay.
Could we amend Rule 13 to just eliminate funding for experts in capital cases?
Sorry, I didn't hear the first part of your question.
Could we
Your Honor.
amend this rule to do away with funding for experts in capital cases?
Yes.
And that would, you think that would be constitutional?
Yes.
The defendants have a claim that it was unconstitutional.
Yes. That is in fact actually the state for non-capital litigation. Non-capital defenders are not entitled to any funding for experts in post-conviction litigation. There is not a distinction within the Constitution between non-capital and capital defendants for expert funding in post-conviction litigation. I believe that is just a policy decision that has been made by the legislature and this court. Finally, the last thing in the Rule 11 grant for this case is whether lack of an appellate remedy violates the prohibition against cruel and unusual punishment. Again, the defendant has made no argument in his brief about how lack of an appellate remedy would violate this constitutional right. And simply put, there is no implication of the prohibition against cruel and unusual punishment from lack of an appellate remedy here. To the extent that there's any due process interaction with the Eighth Amendment in capital cases, it is limited to discretion of which jurors are qualified to be sat on a jury, and then automatic appellate review to avoid any arbitrariness or caprice in the imposition of the sentence. There is no Eighth Amendment requirement that an interlocutory funding decision in a collateral review proceeding be subject to additional appellate review. And unless there are any further questions, I believe it is said that the best skill a lawyer has is to know when to stop talking. So I ask that you affirm the judgment of the Court of Criminal Appeals.
Thank you.
Thank you.
Mr. Harris, you have 5 minutes in rebuttal.
Mr. Harris, do you agree that your client has no constitutional right to any expert funding in a PC case?
There's a statutory, no, because under the legislature, under 4014-207B, the General Assembly creates the right to expert assistance in post-conviction cases. So Rule 13 could not be amended to eliminate funding.
Well, but is there a constitutional right? I think Justice Lee's question went to whether there's a constitutional right. So could the legislature just could they just repeal the statute? There be a
I think
constitutional
that'd be an
problem with
issue, there'd be a question whether that would violate AIC v. Oklahoma and its progeny.
But AIC involved direct review, right, or direct appeal, or trial. I think it was just trial.
I believe it's in a direct appeal
If you don't, I guess
posture.
my question is, if you don't have the constitutional right to funding, how do you have a constitutional violation when you don't get excess funding in excess of the cap?
Well, there is a statutory right to funding, and I think under Ebbets v. Lucy, which does deal with appeals, but as this court has applied in post-conviction cases, when there's a statutory right to post-conviction, when a right's provided by statute, the right has to be meted out fairly, and the proceedings must comport with constitutional standards.
So that creates the underpinnings for due process. Right?
Yes, Your Honor. And also the law of the land clause, our law of the land clause. As far as the right to appeal, Justice Campbell asked about the CJA, and a case that the state cites in their brief that we discussed in our reply in U.S. v. Bloomer. It's a Second Circuit case. The court there makes clear that an appellant's entitled to an appeal and a judicial determination that impacts a defendant's sentence or a collateral challenge to a conviction or sentence. And recently in 2018, the United States Supreme Court held in Estes v. Davis that the denial of a habeas petitioner's funding request is a judicial determination subject to appellate review. In that case, they specifically rejected the state's argument that it was an administrative determination. As far as whether the claims are properly before the court, as we discuss in our briefing, that we seek relief under Rule 11, and according to the rule itself, not even looking at Hodge v. Craig, but Hodge talks about this, that we must include in the application for permission to appeal and in the brief statement of the issues they desire, we have to present an argument with respect to each of the issues presented. And we did that both in our application and in our briefing. And then even looking at Hodge, both issues are properly before the court. And again, as I referenced Linville, there was a case where the argument's not even in the application, and this court considers and adjudicates the issue. And obviously there is a equal protection issue here, because you have two classes of petitioners being treated differently. You have petitioners who, if at the trial level, if we were denied these experts by the trial court as part of Rule 3 appeal, we could have raised it. But in this case, Mr. Dotson's afforded these four experts, and then has no right to an appeal.
Well, what about Ms. Orr's argument that, even, so those who are denied initially by the trial court, and it goes back, and, let's say the trial court then grants prior authorization on remand, that grant is still, they're then in the same place as someone as Mr. Dotson, right? Because that grant is then going to be reviewed by the AOC director, or the prior authorization is then going to be reviewed by the AOC director and Chief Justice without any further appellate review. Is that right? That's the appropriate comparison?
No, because I think in that first instance, Your Honor mentions, there is an appellate remedy there. Here, There's been no appellate remedy until this point. The reason we're here today, the reason we filed this application is because, as I think Justice Kirby mentioned, we have nowhere else to go. The CCA told us they did not have the authority or jurisdiction to adjudicate this case, and that's the basis for this application and why we're here today. It's this court's the first time, I think, where there's a body that can act and give Mr. Dotson the justice that he's entitled to.
So what do we do with the fact that the trial court's order merely authorizes payment? Trial court is not in a position to order payment, and, and the appellate court reverses that order. All the trial court can do is make factual findings that authorizes payment. It doesn't direct payment, and it cannot do that. That is only done at the level of the AOC director and the Chief Justice.
Again, Your Honor talks about a situation where there's some sort of interlocutory appeal, where if the appellate court chooses to overturn the trial court, that they're, as a body, they're making a judicial determination.
But my point is not on the finding of necessity and so forth. That goes into the authorization. In other words, that allow the AOC director and the Chief Justice to go ahead and grant that. So it's not, the decision of the AOC director and the Chief Justice don't go to the underlying factual findings. It's just the answer to the trial court's authorization.
And the authorization is based on finding a particularized need and extraordinary circumstances, which are judicial determinations. So when the AOC director and Chief Justice in this instance are vacating the orders.
Doesn't vacate the order. It just doesn't grant approval of it. There is a difference. All the trial court does is authorize. And then the AOC director and the Chief Justice say, we do not agree to approve it. That's not overturning, it's not vacating, it's not doing any of that.
But the General Assembly vests power in the post-conviction court to make that determination, not in the AOC director and not in the Chief Justice acting as an administrator.
What language is there in the statute that indicates that the trial court has the authority to order payment? They only authorize it.
I think under 4014-207B, that the General Assembly vests the post-conviction court, the trial court, with power to grant expert requests.
Thank you, Mr. Harris. I think we're out of time.
Thank you, Your Honor, for your time and consideration.
Appreciate the good arguments this morning. We're adjourned.
All rise. Solemn court now adjourned.